Hello and greetings. My name is Rajana Valkish, and in this video I will be talking about the 3 certainties required to create a valid trust, followed by the rule decided in the case of Milroy, the 5 exceptions to the rule together with the analysis of whether the maxims contradict the settler's intentions. To start off, it is the cardinal rule in equity that to create a valid trust, the settler must have proprietary right to the property at the time of declaration of trust, as affirmed in Wanita Sarau Berhad. This is followed by the 3 certainties stated in Knight that needs to be present and satisfied when settler intends to declare the trust and give trustee legal ownership to the trust property. The 3 certainties are certainty of intention, certainty of subject matter, and certainty of object. The case of Milroy was regarding the transfer of shares in a company that was not registered in the company's book, and the formalities required for the transfer was incorrect, which renders the trust incompletely constituted, and it was held that it was not the settler's intention to appoint himself as a trustee of the shares, but to vest it on the trust on Lord as a trustee. And the incorrect form and non-registration showed flaws that created the first maxim of equity: will not perfect and imperfect give, because for the donee who brought forward the claim, equity will not aid a volunteer due to no consideration. Lord Justice Turner has stated the 3 method that is recognized in equity in making a gift, which is where the settler makes an outright gift, transfer the property to a trustee to hold on trust, or declares himself as a trustee to the property. However, the first 2 methods I've mentioned will have an issue if the formalities for transfer of legal title is not satisfied, and the title is not properly vested on the intended donee or trustee, which would render the transfer an imperfect gift. He goes on further to state that there is no equity to perfect and imperfect gift because equity will not assist a volunteer. Conversely, only the 3rd method, which is declaring himself a trustee to the property, is recognized as valid declaration of trust. To deem the trust valid and effectual, the settler must have done everything according to the nature of the property stated in the settlement, which is necessary to be done in order to transfer the property. For instance, transfers of legal title in land to a trustee in Malaysia needs to be by registration in the trustee's name under Section 344 Sub 1 of the National Land Code 1965. A case that followed the strict rule in Milroy was Refry, where Justice Romer in this case refused to perfect an imperfect gift of shares because the settler did not do everything he was required to at the time of his death. The settler showed the intention to make a gift, not intention to create trust. Over the time, in some modern decisions, this strict rule of Milroy have been circumvented to ameliorate the strictness. And you can see in Chitram, Lord Brown Wilkinson stated that although equity will not aid a volunteer, it will not strive officiously to defeat a gift. And you can see that equity courts will intervene only on the presence of the 5 types of exceptions. And for the first subsection, the donor must have done everything in his power to transfer his legal and beneficial interest in a property to the donee, such as the decision in referring to Rose 1949, which concerned transfers of share of a company which at first refused to register the transfer until after the settler passed away. And in this case, the donor had done everything in his power, and it was up to the third party's duty to register the donee's name for the shares. Justice Jenkins stated this decision was different from Milroy because the donee's legal title would only be perfected on the discretion of the directors, which is the third party, which was not something up to the settler. This is further affirmed in Rose 1952, where Lowry and Todd in their article stated that this case was more towards a constructive trust, and Rose merely wanted to give away his property, not become a trustee. But the analysis then concludes that Rose declared himself a trustee. Many people believe that equity should weigh favorably on someone who seeks to pass property to another, and that imposing trusteeship is absurd. Again, the author suggested that this case to be regarded as analogous. However, Lord Brown Wilkinson in Choi Tram International stated that although it won't aid a volunteer, it won't officially defeat a gift. And according to Oliver Smith, this case supported flexibility while hinting at the idea of unconscionability. However, the author Garten criticized the decision in Choi Tram, whereby he noted on the absence of the certainty of intention, which is a cardinal rule to create a valid trust. Garten claims that upon a liberal reading of English language will allow one to jump from a declaration intending to transfer ownership to the trustee to a declaration of the settler as a trustee. Moving on to the judgment of the case, Pennington in 2002, after a long while, has received various criticism from commentators as a bad law due to its big deviation from the rule in Milroy and the confusion from the two previous cases of Rerose and Choi Tram. This case has seemed to radically reform and reinterpreted the existing law on the equities maxim that is being discussed. The shares passed to Harold in this case was not included in the testator's will and is not part of the donor's estate. Lord Justice Clark gave a controversial reasoning by claiming that it was not necessary to do more than just signing the transfer form, and that alone amounts to a valid trust. However, and Hudson stated that Clark was just extending the Rerose principle beyond its former boundaries, and this could be difficult to accept for some because it totally moves away from the requirements in Milroy. And Lord Justice Arden's humanitarian intention to balance the wind of the shorn lamb, according to Pawlowski, is evocative of Lord Danning's approach of creating new rights in equity where the needs of justice is needed, as well as his famous comment that equity is not past the age of childbearing. And Lord Justice Arden, critic of the paternalistic objective underlying the maxim to safeguard the donor, demonstrates how much Pennington deviates from the traditional approach in Milroy. You can see that it can be seen in Sutherland's article, where he further affirmed in his article that the outcome of treating all imperfect gifts and trusts as complete, where there is clear intention, would undoubtedly change the maxims of equity does not aid the volunteer or perfect an imperfect gift. Despite Pennington being the case for the judges in Zettel and Kay to refer to in making their decisions due to stare decisis, Griffiths appear to state explicitly that insofar as perfecting an imperfect gift is concerned, the Rerose test is the one to use, and it largely ignored Pennington. The most recent case would be the judgment of Han and Mahmoud, where Judge Marcus' analysis of unconscionability is imprecise, lending credence to Pennington's well-known criticism that using unconscionability as the touchstone in this context gives judges effectively unfettered discretion as to whether an incomplete transfer should take effect in equity. Hence, Pennington is an example of equity that is on the move, constantly developing in the interest of justice. The uncertainty contained in the Pennington judgment provided a chance for the rule to be clarified, constrained, and delimited. In Malaysia specifically, the rule in Milroy is recognized, but it is not applied. This is seen in Lee Ang Teh and others because the facts did not lead to an incompletely constituted trust. However, in Kwan Teck Meng and others, the court applied Rerose principle where the transferee becomes the beneficial owner of the land, although the legal title will not vest on him until transfer is registered. Thus, it can be seen that although there is an agreement between the donor and the third party, which was the lessee, the new registered owner has locus standi to recover the ground floor because he has done everything in his power to show his interest in the land. So we can see that Malaysia recognizes Milroy but applies Rerose instead. And continuing to the second exception would be through the fortuitous vesting of legal title in trustee, where the intended trust is considered perfected when the legal title vests in the intended trustee, although in a different capacity. This can be seen in Raleig's will trust case, where Raleigh created a remainder interest in his residuary interest estate for his two daughters, Helen and Irene. Irene's husband was appointed the trustee to Helen's trust and a promise to transfer her property to him in 1924, which amounted to self-declaration of the trust pending transfer. Later on, in 1946, he was appointed as Raleigh's sole trustee, and therefore, the trust is properly constituted where he vests the legal title to the whole of Raleigh's residual estate and simultaneously becoming the legal owner to Helen's share. The judge in this case stated that it was a fortuitous event that would have a different result should he was not appointed a trustee to Raleigh's trust. And moving on to the third exception is donatio mortis causa, or we'll shorten it DMC, which is defined as a gift given in anticipation of death and with the understanding that it will take effect only if the settlers die. It is not necessary to express the condition if the gift is given in contemplation of death and there is nothing to suggest otherwise. The court infers it. The gift forfeited if the settler recovers. As a result, a DMC cannot be an absolute and irreversible gift. The three conditions to satisfy for a valid DMC is stated in Cain and Moon by Lord Russell, where a gift to be made on contemplation of death, delivery of subject matter, and gift conditional on death. Even if settler died due to a different illness than what was anticipated when the gift was created, Allington decided that it does not defeat the gift, and they still show that settler did it in contemplation of impending death. Going further, the rule in Strongberg created a rationale where a person cannot bring an action against himself. Here, the coincidental appointment of the debtor as the executor of the creditor's will operates to extinguish the debt owed by the debtor. In Stewart, the vesting of the property in the executor as the testator's death completes the imperfect gift made in the lifetime. This shows that equity will be set aside to perfect a gift to comply with the intention of the testator. In Sheikh Hassan bin Abdullah al-Jafri, the plaintiff failed to show evidence that the deceased gave a valid gift to him by way of intention during deceased's lifetime that remained until his death. This, however, can be seen in Lee Han Ki, where the gift is perfected by the appointment of defendant as one of the administrators of the deceased estate. And the last exception, proprietary estoppel. Proprietary estoppel is remedial doctrine that aims to compensate a claimant for detriment incurred as result of relying on representation of the defendant, or to give effect to the expectations established by acting on reliance on a representation. Conner and Major stated the three elements of the estoppel, where the donor makes a representation to the donee, which is like a promise on which the donee acts to her detriment. The court will prevent the defendant from turning back on that representation, which is a promise. And you can see in Rebasham, the court passed the gift of the house to the stepdaughter, as she has acted in her detriment on the reliance of the oral promise made by the deceased, which is her stepfather. A Malaysian case that applied this estoppel is Teng Chung Yuan Sendian, which was to protect plaintiffs' equitable interest due to lease with an unspecified duration. Here, after the death of the testator that left no will, proprietary estoppel will perfect a gift if the three elements are satisfied, which follows the intention of the settler. In conclusion, based on the discussion I have made in this video, the maxim that equity will not perfect an imperfect gift and equity will not assist a volunteer thus contradicts the settler's intention. Because of the latter maxim, trust will not be implied in order to fix an imperfect gift. However, it is still up to the court's discretion upon analyzing the facts, because there are instances where the gift was made in contemplation of death, or settler has done everything in his power to give the gift to the donee, but before the gift can be completed, the settler dies, and when the donee as volunteers seeks the gift, the maxim prevents them from it. Thank you.